Hey, we're back. We're back to A Taste of Justice with Professor Angela May Kupenda. Remember, I'm a professor at Mississippi College School of Law, but I give you that information for identification only. Views expressed here are my own. Now, we stopped last time looking at Section 1983. And we were wondering who is acting under color of law. Remember, there was the case about Mr. Monroe, where the Chicago police came into his home without a warrant, ransacked the home, and also took him in for questioning, but did not press charges. The police argued that they were not acting under color of law because they were not following the law. And I ask you to think about that, and I would tell you what the court ruled. Well, the court ruled that they were still acting under color of law, even though the officers, were acting unlawfully. Acting under color of law means acting with the authority of the law. It's similar to a concept we talked about on the common law videos. Do you remember the concept? The concept is called state action. So in that case, the court said you are acting under color of law. That part of the test was satisfied. Now, the officers also argued that because Section 1983 was enacted by Congress pursuant to the 14th Amendment, they argued that it was enacted because the states had failed to act to protect Black citizens. So their argument was that Mr. Monroe needed to first go to the state and try to get relief. And if that didn't work, then he could file a federal claim. The court said, no. He can bring a suit under state law and under 1983, all in the same action. It is 1983 is a supplemental remedy, and he did not have to exhaust all state remedies first. So the holding in, excuse me, I coughed my elbow. The holding in the Monroe case is that acting unlawfully can still be acting under color of law when you're acting with the authority of the law, right? Now, the other case that we talked about was Bivens. And in Bivens, the federal officers came into his home and they said that, no, yes, we did all of that. We did a visual strip search of you. We shackled you. We did all of that. But we're federal officers. Section 1983 only applies to the state officers. The court said, we could wait on Congress to act, okay? We could wait and see if Congress changes it to say it also applies to federal officers. But the court said, we're not gonna wait. We're gonna go ahead and say that this claim can be allowed, that I guess in line with the spirit of 1983, that an action can still be asserted against federal officers. And that action is very similar to a 1983 action, but it's called a Bivens claim. Yes, a Bivens claim after Mr. Bivens. Now, all of this probably sounds really confusing. When you look at the bottom, when you look at the text, you see it says that any person, every person acting under color of law who deprives another of their constitutional rights shall be liable. This is so complicated. You're right, it is. That's why we're having this taste of justice. Could Congress straighten out a lot of this? It could. Could the Supreme Court straighten out a lot of this? I believe it could. But here we have what we have when there are these civil rights lawsuits generally brought under Section 1983. Now, the last point I want to make to you, because I'm getting sleepy, the last point I want to make here is that in all of these cases, it's really about the state. Is it not? It's about the state in terms of how it is training its officers and employees. It's about, at the hands of the state, so to speak, that these deprivations occur. So the question becomes, why not just sue the state? The answer is, though, because of something called the 11th Amendment. The 11th Amendment grants sovereign immunity to the state to a degree. Look, there was a case long ago where some individuals actually got a judgment against a state and they wanted to receive payment on that judgment. And a state said, you can come and try, and if you do, you might be hanged. The idea is the state said they're sovereign and they're protecting their treasuries. So the court has said, yes, you can sue the state, but the state must consent to be sued. Now you may say, why would a state consent to be sued? Well, you know, there are traffic accidents, there are fender benders, there are other types of injuries that occur where a state officer is in the wrong and the state says, we want to pay for that. And so many states have what are called tort claim acts. Now, there's another way to sue a state. The court said that Congress can abrogate sovereign immunity, meaning Congress can say in 1983, sovereign immunity doesn't apply, you can sue the state. But the court said Congress hasn't done that yet. So how did we get these 1983 actions? Oh, it's a doozy. The court said, even though you cannot sue the state of Alabama, the state of California, the state of Mississippi under 1983, you can sue the state officers. Now, if you're looking for prospective relief, like an injunction to tell the state you can't do this anymore, I don't want damages, but I want an injunction to tell the state it can't do this anymore, that's a suit against an officer in their official capacity. You're not really saying they did anything personally wrong, but you named them. So if you name the governor and you're seeking this injunctive relief, for example, then when a new governor comes in, that next name gets substituted. You're suing the office. In a way, you're suing the state, but you can't sue the state directly because of sovereign immunity. Now, I know you think that I'm just confused, but all of this is indeed the law. And if you look at the text I have below this video, I give you the names of the cases so you can check behind me. Now, there's one other way you can sue officers of a state. You can sue officers of a state in their personal or individual capacity. But if you sue them in that way, they may be entitled to immunity for some of their actions. Immunity. And it's an immunity from suit. So therefore, if a plaintiff brings suit, the government is going to try to establish immunity it's going to try to file something as soon as possible, a motion to dismiss, for example, a summary judgment, in order for the case to go away, because immunity is immunity from suit. If the officer is going to be immune, the court says the case needs to go away as soon as possible so the officer can get back to work. And I know I'm rushing here. Play it again, play this video again. And then in the next clip, we're going to start to discuss those various forms of immunity, right? We're going to look at judicial and legislative and executive immunity, and then we'll be back in the area of the types of cases and the types of issues you will likely be seeing in cases involving some issues that are ongoing. Again, this is a taste of justice with Professor Angela May Kupinda. The goal is to just get a little taste of justice by learning about the Constitution and learning about civil rights actions. The other goal is for my students who I'm instructing remotely this semester to just give them a little bit more as they are now reading these lengthy opinions that I'm summarizing here as we prepare to have discussion together next week. So watch for 2 more clips within the next couple of days, and then after that, it'll be a week before I see you. Thank you again, and remember to subscribe, and remember to sign up for notifications. Okay, bye-bye.